What happens if you die without a will in the state of Florida? Well, let me tell you. People call me all the time and they say, I need to draft a will because I don't want the government or the state of Florida to take all my assets when I die if I don't have a will. And I'm not trying to talk myself out of drafting a will for a fee, but the reality is the intestacy statute in Florida is designed so that it's the least likely that the state of Florida will actually take your stuff when you die if you don't have a will. So here's a very abbreviated form of what happens when you die. So you die without a will. The first thing the statute looks to is, do you have children? If yes, then they make a note of that. The next question is, do you have a spouse? If no, then your children get all of your assets equally. If you do have a spouse, then the next question is, are all of your children a product of the current relationship with your current spouse? If the answer is yes, then your spouse gets everything. If the answer is no, you have children from outside your current marriage, then typically your spouse gets half and your children get the other half. That's typically not what people want. Now, if you change the facts and you don't have children, but you do have a spouse, then your current spouse takes everything. What happens if you have no children and no spouse? Believe it or not, the statute looks to your parents. If one or both of your parents are alive, then they are your default beneficiaries. If your parents have predeceased, then it's brothers and sisters. If your brothers and sisters have predeceased, then it's nieces, nephews, great-nieces, great-nephews. Well, what if you're an only child? I'll tell you. It goes up to the grandparents' generation. And so if either of your grandparents are alive, typically they're not, but they would be your beneficiary, followed by aunts and uncles, then cousins, and then whatever comes after that family tree. So it makes it very difficult or very rare for someone to die having no spouse, no children, no parents, no brothers, sisters, nieces, nephews, great-nieces, nephews, grandparents, aunts, uncles, cousins. Usually there's somebody in the woodpile left over. They get all your stuff. And the problem is that's usually not where you want your stuff to go. So if you don't want to leave your assets up to chance of which one of your family members happens to survive you being the closest in relation by the statute, then you should take initiative to draft a will or a trust and take control of the two important decisions. Who's in charge? Where does my stuff go? If you do nothing, the state of Florida makes the plan for you. But the only way the state of Florida keeps all of your stuff, it's called escheating to the state, is if you have no one in your lineage that we've talked about. So no spouse, children, parents, brothers, sisters, nieces, nephews, grandparents, aunts, uncles, cousins. Have a great day.